hello, everyone. My name is Lisa, and I'm very grateful for the opportunity to be here today, even though I have to do it electronically. But thank you so much for the Center for Computational Law. And let's begin. Don't worry, my presentation won't be as smart as the previous one. So yeah, so so sorry. So I'm here from ETBL Asia, and we are a think tank that does some research on the subject of artificial intelligence and how we could use it in litigation and in artificial intelligence field in general, like what sort of legislative changes are needed across different jurisdictions in this field. But today I specifically wanted to talk about litigation because, as we all know, lawyers across the globe deal with numerous numbers of precedents and past judicial decisions. So in other words, they deal with huge amount of data, and the same rings true in regard to artificial intelligence. So I started thinking, for instance, if precedents, and I've always been fascinated by precedents and common law system in general, are strictly bound by the past decision, would it be possible for us to use AI to create a perfect precedent system? Or for instance, would it be possible for AI to play a significant role in resolving disputes in general? And when I say AI, I use it as a broad umbrella terms, meaning both like narrow AI and general AI, because as you can see, we already see that there are positive examples of artificial intelligence use. For instance, one of the Australian courts passed a detailed decision on technology-assisted review. Yeah, thank you very much. Where the court specifically said that because manual review of the documents is too expensive, the use of technology is required. And what I found interesting in this case is that the court actually went forward and did a bit more than solving a particular case, but they actually issued a special note where they said that if the court thinks that the use of technology would be more beneficial for the task of resolving dispute, then technology could be used even when one of the parties do not give their consent for such use. So I think this is one of the examples where the judges recognize the importance of modern technology and the fact that it would improve the litigation process so significantly that the parties are not even required to specifically ask, or what's more important, to consent to it. And another angle to consider, I think, is the fact that judges themselves use mathematical approach in general. For instance, in Singaporean case, Vasanta Dislas Joseph and public prosecutor, the mathematical approach was used to create a table for sentencing first-time offenders, specifically drug traffickers. And then this approach sort of caught on, and it shows that the mathematical approach didn't replace the legal reasoning, of course, but it was used as a helpful instrument. If we are talking about mathematical approach, of course, who better to sort of resolve this issue than modern technology. But there are other examples. So for instance, in English case, Aaron Clark, the court decided that we do not convict people in this court based on statistics. And this was a fair argument as well. So we cannot sort of imagine the situation where mathematical approach or like mathematical reasoning would be the only way to move forward with the case. And this is why I think it's important for the judges to decide whether they find helpful what AI is suggesting, or what different algorithms suggesting them in regard to a particular case. Because what we need to remember is that when judges make decisions, they ultimately exercise their judicial function. And if we look closely at what judicial function means, it was actually discussed in another Singaporean case called Mohammed Faisal bin Subtuin Public Prosecutor. We can see that it can roughly be translated to 3 stages. The making of finding of fact, the application of relevant legal provisions to the fact, and clear overview of rights and obligation of the parties. And I think that if we look at these 3 stages separately, we can see that there is actually nothing specifically human, so to say, about that. If we ask AI to find the relevant legal provisions, to compare it to the facts of the particular case, and then find whether one of the parties possess any rights and the other party possesses any obligation. That seems like a straightforward task. But at the same time, to apply the law, it should first be interpreted. And this is where I think the catch with using artificial intelligence in litigation is, because even a relatively straightforward case can cause confusion if there is no legal definition for a certain event, for example, or something is not spelled clearly, or the law operates in categories that are no longer relevant. And we can see it even in the famous examples. For instance, all men are created equal could be interpreted as being discriminatory to women and non-binary people, since they are not included in this category. Or sometimes even legal definitions vary from case to case. And for example, the definition of a family in a divorce proceedings will slightly differ from the way family is described in a dispute about inheritance. And all this factor shows that actually the data that that is fed to AI is a bit messy, so to say, and that more complicated cases would require further analysis and so on. And also speaking about determining the rights and obligations, it is also a difficult task because as we all know, sometimes even human judges cannot decide on the outcome of the cases themselves, and judges write separate opinions that sometimes are more persuasive than the general judgment. So this is an example that shows how important the data is, because obviously AI needs the data to learn. And this is where we are entering sort of muddy territory, because we are saying that there are some examples of the use of AI where it's basically harmless, and there are others that are not so. So for instance, if we say that AI contract review software is capable of checking agreements quicker and more accurately than human lawyers, then it's possible to use it, for instance, in like mediation stages of the dispute to sort of show the parties their opportunities going forward. But if we are talking about, for instance, programs that were predicting judges' behavior, which was a practice that caused controversy and was prohibited in France, from a more ethical standpoint, of course, this seems more questionable. So perhaps one of the more sort of appropriate ways to use such technology would be to ask AI to predict how a particular contract will play out if the case go to court, instead of focusing on the specific area of predicting behavior. And particularly because the data is so, not to say insufficient, but so complicated, some legal professionals even suggest that AI should be used in the judicial function precisely because humans do not do such a great job to begin with. So, for example, Professor Woloch in his paper, Chief Justice Robots, basically say that AI shouldn't be perfect at exercising law because humans don't set the bar very high. So this is sort of one way to look at it. And I've noticed that obviously this caused some controversy. Because while, yes, human like lawyers and human judges are imperfect and the data is imperfect, at the same time, we cannot avoid using humans as a baseline for both teaching artificial intelligence and measuring its success. So this is a complicated situation because research shows that lawyers with more experience, for instance, didn't become better at predicting case outcomes in comparison with their younger peers. So the question is like, then how are we going to say that AI will be able to predict outcomes with 100% certainty as well if we don't know how this teaching process actually works even amongst ourselves. So perhaps what I think is better is to use a client-oriented approach where maybe some clients would be more comfortable hearing predictions from a human lawyer, and some may prefer statistical analysis from AI that would at least support the lawyer's memorandum, because sometimes human professionals cannot even agree on the different interpretations themselves. And I think it's important to remember that the system of checks and balances sort of required, and obviously it's not a question of a competition between like legal tech and AI and lawyers. And lawyers should use modern technologies to their benefits and for the society benefits. They should supervise AI, and also an additional fact why they should do supervisions is that to start with, if we're talking about litigation in particular, not every judicial decision is available to the public. Some contain sensitive information. A lot of cases are simply not significant enough to be reported. So as a result, navigating through many cases can become a daunting task for a person who is not legally trained. So on the other hand, it is a responsibility of the legally trained professionals to supervise a system of AI where risks related to it are minimized. And it is unfair to say that this risk would be eradicated completely, as every legal system can be compared to a living organism and mistakes are bound to happen. But I think that the general idea that the idea behind the use of AI in courts is not and should not be similar to a blind following of the potential outcomes AI can reach, but rather the application of modern technologies in centuries-old institutions. And after all, we need to remember that AI should be used in ways it can benefit the society, because it brings efficiency, consistency, and access to justice. And the most important thing, I think, is that AI and modern technologies in general should always be used for good. And I've said before that humans are imperfect, but we should always strive to be kind to each other. And I think this is the main lesson AI should take from us in general, and also specifically when we're talking about using AI in litigation to resolve disputes, because we should always remember about the basic principles of justice and humanism. And I think this is why sort of it's important to create the system where technology is being used for good, and there is a cooperation between human lawyers and AI, and also just clients and people who are themselves trying to find the common ground and trying to determine their own rights and obligations in any litigation. Yeah, so this is, I think, ultimately my point, that even though data is the new oil, we need to be sort of aware of its consequences, specifically when it comes to case law and precedents and using artificial intelligence, like practices like predicting judges' behavior or something like that. So thank you very much for listening. I apologize for the for my initial problem with the camera, and thank you very much again for inviting me. I'm really grateful, and thank you for listening. If you have any questions, you can contact me using my email address below.
Okay, thanks, Liza. Does anyone have any questions? Yes. No.
Yeah. Thank you for your talk. You made that point twice of saying that predicting judges' behavior is ethically problematic, and you pointed to what I believe is the French statute that sees data protection issues, which I have trouble relating to. So while given an opportunity to talk to someone that sees it that way, I'm wondering, what is it that makes that problematic? Because the way I see it is people are in court, they perform a social function. They decide about important societal matters. Is it really a problem if people try to know before the fact whether or not they should bring a case, like what judge they should bring it to, what the best arguments would be? You seem to imply that that is a problem, and I would like to better understand why.
Yeah, thank you for the question. So actually, in my opinion, I don't think that it is such a harmful practice that it should be prohibited at all costs. Like, obviously not, because even human lawyers, when they're bringing cases to courts, obviously they try to sort of predict judges' behavior. But I think that the issue here lies with like the facts, with the fact that the judges themselves do not want to be read by basically like modern technology, because let's just say that we have a judge who heard like 10 similar cases, and in every in every case he was siding with the plaintiff, for instance, or let's say he was siding with the defendant. So the plaintiff in an 11th similar case says that no, this judge, he always says that the defendant is right. So it's better to find some ways to switch the judges. And I think it's a little bit unfair to the judge because basically he's being sort of prohibited from doing his job just on a simple assumption that he will do. He's just it's based on assumptions that he won't listen to the arguments to the particular case in full, but just reach a generic decision, so to say. And so this is, I think, why there is a problem with this situation. Like, it's one thing when human lawyers sort of judge, if I may say so, the behavior of the judges, and they say, listen, we think that this is not a good candidate for us, but we will try to do our best to switch him or like to persuade him in our favor. But it's another thing when you just have sort of algorithms that tells you that no, this judge is no good. So this is my take. why this practice may be a little bit controversial, so to say.
Follow up, if I may. Why is it one thing when a human does it and another thing when an algorithm does it? I honestly wonder, or I have trouble seeing the difference.
I think that the difference is when human lawyers try to predict the judge's behavior. They do not know for sure, right? So they can just look at the past cases and say that, well, we suppose that this will be the outcome of this particular case, because we as humans are subjected to our own biases, and it's better to understand another human, so to say. But when it comes to technology, then obviously the ideal situation is when AI is not subjected to any biases or any troubles of the human mind, and they are supposed to reach an objective decision, but maybe this is like not always the case, because I imagine even in because so I agree with you that the situation is not that straightforward, that it's okay when humans do it, but it's not okay when we use technology for the same purpose, because ultimately the purpose is the same. But I think that's where the difference lies, that for the judges, for instance, it's easier to deal with other lawyers and to sort of say, okay, those lawyers may think whatever they think, but it's much harder to face the sort of objective decision when it comes to algorithms.
Okay, and we have a question from the online audience. Can I call upon you, Guido?
Well, it's a comment about the current answer. So the real reasons why generally we don't accept, let's say, AI solutions, it's because most of those solutions are not explicable. So essentially, we don't know the reasons why we reach a particular conclusion.
Yes.
Why, if you ask a human, the human can provide the justifications. What in general, if you use some machine learning, in particular, if you use a deep learning, you don't know what is the answer, because in general, you're not able to understand the 10,000 parameters used and to follow the neural network used for it. And then also the other reason is because the answer depends on the training data. And then since it's possible to have discrepancies, as soon as you have more than two preferences, if you use the R impossibility theorem, then essentially there will be some bias built in any machine learning algorithm, in particular when you have conflicting preferences, and then essentially you cannot reconcile, and then you don't know the reasons why. That is the reasons why, in most cases, we don't accept AI solutions, in particular machine learning and deep learning solutions.
Yes, thank you. Yeah, I think that's true. Yeah, and that's sort of what I was trying to say. Yeah, thank you.